Supreme Court of Florida is now in session. Please be seated.
We now come to the third case on the docket today, Newberry versus the State of Florida.
Thank you, Chief Justice Kennedy. May it please the court, Mose Bracey on behalf of Mr. Newberry. I hope to focus on one multi-part claim for relief. That claim draws in full on issues 2 and 4 in the initial brief, on part of issue 3 in the initial brief, and on part of point 4 in the reply brief, which deals with harmless error. In short, this court should reverse for, at a minimum, reevaluation of the mitigating circumstances and sentence because 1, the trial court erred when it concluded that the impaired capacity mitigating circumstance was not proven. 2, the trial court erred when it concluded that 5 other mitigating circumstances were established but, quote, not mitigating, end quote. And 3, at least considered cumulatively, those 6 errors were not harmless. With that in mind, this case is about ensuring that in sentencing a man to die, the court properly accounts for all circumstances that reasonably could serve as a basis for imposing a sentence less than death, and critically that it do so in a manner that allows for meaningful appellate review.
On the incapacity factor, on the mitigating factor,
Yes, sir.
Doesn't Dr. Gold's testimony give competent substantial evidence from which the trial court could have concluded that that mitigating factor did not apply or should not have been applied here?
No, sir.
Why?
Well, first of all, Justice Luck, I think I need to focus on the competent substantial evidence standard for a moment and say that standard is not any evidence. It's competent substantial evidence.
It's an expert testimony. I think it was the defendant's own expert, wasn't he? Dr. Gold?
Yes, sir.
How's that not competent substantial evidence? The defendant believes that he's credible. He's presenting credible evidence.
Yes, sir. Well, because this court has said that competent substantial evidence is evidence that's sufficiently relevant and material for a reasonable mind to accept it as adequate to support the conclusion reached. And I would also point out that here the finding that the impaired capacity circumstance was not proven, that involves the application of some standard to some factual findings. And the competent substantial evidence standard would apply to the factual findings. Here, I think, let's assume that implicitly, and I think we can implicitly, the trial court found that Dr. Gold's testimony essentially was that Mr. Newberry's capacity was not substantially impaired, and this is critical, by its low intellectual functioning and intended effects. The reason I say that is because Dr. Bloomfield clearly testified that it was impaired by that.
Here's what Dr. Gold testified to. State, in terms of the defendant at the time of the murder, can you say whether he was able to appreciate the criminality of his conduct, which is the factor here?
Yes, sir.
Dr. Gold, I have no reason to believe that he wasn't. It's a lot of double negatives there, but essentially that's a no.
Yes, sir.
And then the state asks, nor was he able to conform his conduct to the requirements of the law, whether that was substantially impaired. You're not saying that he was substantially impaired, are you? Dr. Gold says no.
Right.
And I know the next question is related to traumatization, but his answer is pretty unequivocal that he's not saying and not testifying, and he has no indication that he was substantially impaired. Correct?
Well, those are his first 2 answers, Justice Love.
Right.
And I think that could be some evidence to support the finding here. But I think in order to determine whether evidence is competent and substantial, those answers have to be put in context. The very next question and answer has to be considered. And the very next question is, so do you understand that Dr. Bloomfield testified that his opinion is that Mr. Newberry's capacity is substantially impaired? Do you share that opinion? Not in terms of his traumatization. And then minutes later, on redirect, the very first question from the defense attorney is, Dr. Gold, the state has asked you a lot of broad questions. What was the specific purpose of your evaluation? And Dr. Gold says, I was asked to evaluate Mr. Newberry as far as whether he's experienced trauma and whether that trauma had a psychological impact on him. And so here, I think it's clear. I don't think Dr. Gold would even be qualified to render a categorical opinion that Mr. Newberry's capacity was not substantially impaired.
What do we make then of, as I understand it, our case law has said that where there's been substantial plans and preparations both before, during, and after a murder, that itself can negate expert testimony of substantial impairment. We have said that, have we not?
Something along that line.
Okay, I know I'm not quoting, but something like that.
Right. Yes, sir.
Okay. Tell me if I have that wrong.
Well, I would want to get down into the details, Justice Luck, and I would say that this court has essentially said that competent substantial evidence exists to refute, to find the impaired capacity circumstance not established, not proven, when there's evidence that the defendant concealed his involvement for others. This court has also said took actions that are indicative of someone who appreciates that their conduct is criminal and could conform their conduct to the requirements of law if they so desired.
Well, what we said is that purposeful actions done during the course of the murder could be indicative of someone who knew that the acts were wrong and could conform, right?
Purposeful actions.
Right.
I think...
So, for example, in Hoskins, we said that the purposeful action of binding and gagging the victim, placing her in the trunk, driving to a parent's house 6 hours away, borrowing a shovel, driving to a remote area, and telling his brother that he hit a possum were indicative of someone who knew that their conduct was wrong, correct?
Yes, those actions are.
Right.
Yes,
Isn't there a litany that the trial court went through? I can read it if you want, but a litany that the trial court went through in its order to show that the defendant here had those sorts of purposeful actions which indicated he understood the criminality of his actions.
Well, the trial court did go through a litany, Justice Locke. I would say that that evidence that the trial court focused on, which the state characterized, and I think this is accurate, as Mr. Newberry taking purposeful actions or logical steps at the time of the crime. And I think we could even say that that was evidence that he took logical steps or purposeful actions to arrange and carry out the crime.
What about his statements to the girlfriend that he was going to steal a car, that he wanted to steal a car? Isn't that indications of a plan?
Mr. Newberry's statement to his girlfriend that he was going to steal a car?
Right.
I'm sorry, Justice Luck.
Okay, and I apologize if I'm getting that wrong. But in any event, why are those actions at the time of the murder and after not indicative of purposeful actions?
Well, I think it's because we need to look at the language of the statute, 921-141, and it basically says that it shall be a mitigating circumstance if the defendant's capacity to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law were substantially impaired. And I think that if a defendant takes logical steps or purposeful actions to arrange and carry out a crime, that's not necessarily inconsistent with him appreciating the criminality or being able to conform his conduct to the requirements. Now, on the other hand, taking actions to conceal their involvement, that is inconsistent with those two prongs. And logically, I think that makes sense because the first situation, arranging and carrying out the crime, that only requires what I would consider first order or first level thinking, being aware of the consequences, getting it done. The second situation involves second, third order level thinking in this sense. Not only is that individual capable of accomplishing an immediate goal, he or she can think, well, the consequences of that would be criminal.
What about when he shot the two police officers that he thought were arresting him for the underlying action here? Isn't that attempt to get away with it?
I think, let's assume that is competent substantial evidence that he could appreciate the criminality of his conduct. The statute is written in the disjunctive. I do not think that's competent substantial evidence that he had the capacity, that his capacity to conform his conduct to the requirements of the law was substantially impaired. And I would point out, the statute doesn't require that capacity be entirely lacking. It only requires that it be substantially impaired.
So let's go to the second part of the issue that you want us to talk about, which is the 5 mitigating circumstances or not. Hasn't our case law said that a trial court can, weighing the evidence, find that it's of no value, even though they found that the mitigator had been proved?
Well, generally.
Yes, in general.
Generally, but I would say that this court has found that, this court has basically stated in Terrese that if a mitigating circumstances is generally considered, if a circumstance is generally considered mitigating, then it's technically relevant and it has to be considered by the sentencer. However, they can decide that it's entitled to no weight based on the particular facts of the case at hand.
Given that the trial court here, first of all, as I understand it, the jury found none of them were found and none of them had any weight. The trial court then said, I know the jury found that, but I'm going to go through each one individually, goes through each individually, finds that some are proven and that some are in fact entitled to weight, and that it specifically assigns weight or no weight depending upon each particular factor. Given that, can't we find that the trial court did exactly what Terrese allows the trial court to do?
No, sir.
Why?
Well, first of all, Justice Luck, I would say that the trial court has a duty to independently consider these circumstances. So the fact that the jury may have not found them to be established, that's not dispositive.
Agreed. And didn't the trial court go through each one and assign weight and no weight to some that the jury had found A, were not proven, and B, that they shouldn't be weighed in any particular fashion?
Well, where the 5 particular circumstances I'm focused on are, and those are the 5 circumstances in issue 4.
Right.
And where those circumstances are concerned, the trial court found that they're established, but that they were, quote, not mitigating, end quote. That was it. My argument is that the most logical and reasonable interpretation of not mitigating is not mitigating in nature rather than mitigating in nature, but entitled to no weight based on the particular facts of the case.
We don't have to read it like that. Can we just read it as I assign no weight to it?
Well, I would say a couple of things. First of all, even if you read it that way, then issue 3 kicks in, which is the trial court abused its discretion by not thoughtfully and comprehensively analyzing the mitigators. But to a broader point, if I could...
Didn't we deal with that in Rogers, though, which said that it didn't need to have a specific explanation for each one? It was simply enough to go through each one and assign whether it's proven and the weight given to it?
Well, I think that really what Rogers said is this court receded from Oyola to the extent that a trial court had to specifically and expressly articulate why a particular circumstance was assigned a particular weight,
right.
which is not really the argument I'm making here. I'm arguing that the trial court failed to find these circumstances mitigating in nature. But the broader point, well, so that would be one response to Rogers. I would then step back a little bit further, and this is a broader point I want to make. But I do think Rogers needs to be placed in context. And as odd as this may sound, I'd like to use the analogy of a tree. And if we think about Oyola's out on the edge of the branches of the tree. Campbell may be the trunk or very close to the trunk, but Campbell's not the root. Campbell's not the root of this line of precedent. The root is actually Gregg versus Georgia, Prophet v. Florida, State versus Dixon. And I make that point because, one, Rogers only receded from Oyola, which would be pruning back the edges of the branches, but there's still Campbell. So there's many branches in between Campbell and Oyola.
Right, but Campbell, and I don't know that I disagree with anything you've just said, but what Campbell seemed to suggest was it's enough for the trial court to go through them individually, assess whether they've been proven or not, and assess a weight to them. In other words, what we don't want is trial court saying, they've alleged all these and I find one to be, this to be more aggravating than that, and that's it. And what we've said is, no, you gotta go through them each individually. Fine. The trial court spent, as I understand it, 14 pages going through all the individual, the 30-something or 20-something catch-all mitigating factors, non-statutory catch-all mitigating factors, and did exactly that, went through and assigned weight to them. How is that not consistent with Campbell?
With Campbell? Well, Justice Luck, as a pure matter of form, arguably it is consistent with Campbell. But I would point out that subsequent to Campbell, in Jackson and Walker, this court said that a trial court, that this court is not able to provide meaningful appellate review unless the trial court thoughtfully and comprehensively analyzes the proposed circumstances. And then I would refer back to what Campbell was built on, which is Gregg, Prophet, State v. Dixon. In those types of cases, the court said things like it's important that the capital sentencer specify the factors on which it relied, articulate its reasons for reaching that decision. In Dixon, this court said that it exercised reasoned judgment as to what situations require death. And that's important because, as we all know, capital sentencers, their discretion has to go through some type of channeling process, I would say. And a crucial component of that channeling process, as this court recognized as recently as Robertson, as the United States Supreme Court said at Prophet v. Duggar, a crucial part of that process is meaningful appellate review. And I appreciate that this is a matter of line drawing, so it doesn't lend itself to a categorical rule, which I know can pose some challenges. But if the trial court doesn't thoughtfully and comprehensively analyze the circumstances, this court essentially has to substitute itself for the trial court and say, well, it's not mitigating, here's why.
It seems tough to me to read this order, which seems pretty detailed to me, to lead to the conclusion that the trial court did not thoughtfully go through the mitigating factors, especially where the facts are the jury found none of them were proven, and yet still individually went through each one, individually found some proven, and then individually assigned weights to some, not categorically saying none of them had any weight, but assigning weights to certain ones and not as to others. It's hard for me to say that under that facts that I've laid out, and tell me if I have those facts wrong, that's not thoughtful, that's not the thoughtful review that we're talking about.
Yes, sir. Well, two things, Justice Luck. Again, I would just return to the fact that under Florida's capital sentencing scheme, 921-141 requires the trial court to, quote, address the mitigating circumstances. And at one point it says, in its sentencing order, in essence, it shall consider the aggravating factors found by the jury, but all mitigating circumstances. So again, I don't think the fact that the jury didn't find these really has much bearing here on this issue. The second thing would be, in the claim I'm hoping to focus on today, I'm really zeroing in on these 5 particular mitigating circumstances.
What were the mitigators the mitigating circumstances that the trial court did give weight to?
Mr. Newberry's intellectual impairment, his low IQ, I believe, and I'm sorry, Chief Justice Kennedy, there was one more along those lines, but there were 3. He gave moderate weight to 1 and slight weight to 2. And I do apologize that I can't recall that third.
I have one follow-up question on the impaired capacity
Yes, sir.
mitigator and your issue. As Justice Luck alluded to, and I think you did too, this was tried using the interim jury instructions that had the jurors actually record their votes as to whether they found individually the existence of mitigating factors that were argued to the jury. And the jury unanimously rejected that particular factor. Does that have any relevance to our consideration of the legal issue that you raised regarding the trial court's decision?
No, sir, I don't think so.
And why
Justice
not?
Laws. Well, because again, the statute requires the trial court to independently make these findings. So I think if the trial court was to basically say, well, the jury didn't find it, therefore I don't find it, that would, in essence, be an abuse of its discretion.
But he didn't do that.
Right. Well, I guess the main point I want to make is that the fact that the jurors did not find that should not prevent the trial court from finding. I think the trial court has to independently determine that. I'm not necessarily saying that factor could not somehow weigh in that, but I don't think that fact would basically say, well, the judge did what he had to do because the jury didn't find it. I don't think that would be an appropriate relationship.
So what you're saying is, and to follow up on that, you're making a statutory claim, not a constitutional claim, because constitutionally, the jury, the defendant here got the rights that he was entitled to under the 6th and 8th Amendment by having a unanimous jury findings with regard to these things, correct?
Well, of course, issue 1 in the brief I take, I'd take an issue with that.
I understand.
Justice Luck, but yes,
That's been decided against you.
Yes, sir.
Right.
Yes, sir. But here, this particular claim I'm making would be more of a statutory type
Okay.
of claim. Yes, sir. If I could briefly address the harmless issue. Again, these 6 errors, at least considered cumulatively, were not harmless. And I would point out that in these types of circumstances where a trial court has erred in what I would call improperly considering mitigating circumstances, and here I'm thinking about cases like Covington or Tansey versus State. In that situation, this court has essentially applied a 3-factor type of test. Factor 1 would be whether, setting aside those improperly considered mitigating circumstances, did the trial court find and weigh multiple other mitigation? Second of all, was there significant aggravation? And then finally, as far as the circumstances that were improperly considered, were they minor and tangential? And here I would argue that all 3 of those factors weigh in Mr. Newberry's favor. First of all, here the trial court only found and weighed 3, whereas he improperly considered 6. And second of all, at least relative to other cases in which this court has found this type of errors harmless, I would say that the aggravation here was not significant. In particular, especially heinous, atrocious, or cruel, or cold, calculated, and premeditated were not involved. The final point is that these circumstances were not minor and tangential. First of all, the impaired capacity circumstance was the only quote-unquote statutory mitigating circumstance proposed. Second of all, that circumstance, as well as Mr. Newberry's poor impulse control, were directly related to his culpability, which I acknowledge does not have to be present for a circumstance to be a mitigator, but it would be reason to give it more weight. I would also point out that Mr. Newberry's, the evidence of his loving relationship with his family, this is not a situation where a capital defendant called family members in who said, that's my brother, I haven't seen him in years, but that is my family. Here, there was persuasive testimony that Mr. Newberry maintained an ongoing relationship even while he was in prison with his children and grandchildren. And so finally, I would say that relative to cases, compared to cases such as Crook, this case would be more analogous to that type of situation on the issue of harm. On the other hand, it would be distinct from cases like Tansey on the issue of harm. And if there are no further questions, I will reserve the balance of my time for rebuttal. Thank you.
May it please the court, Michael Kennett for the state of Florida. The appellate focused on issues 2, 3, and 4. I would like to do the same absent questions on issue 1. I'd also like to briefly touch on issue 5 as well, regarding proportionality. But as far as issue 2 goes, the appellant challenges the trial court's finding that competent and substantial evidence did not support the mitigator, the statutory mitigator found in 921-141-1417F, that the capacity of the appellant to understand the criminality of his conduct and to comport his conduct with the requirements of the law was substantially impaired. As appellant pointed out, that is a two-pronged mitigator, the capacity to understand and the ability to conform. There was no dispute at all about the first prong. The defense's own experts testified that the appellant could understand the difference between right and wrong. So the only issue with regard to that mitigator was whether or not there was evidence to show that the appellant couldn't conform his conduct to the requirements of the law. And there's one piece of evidence very on in this armed burglary or armed robbery that shows that he could. The appellant secured a vehicle from one of his co-defendant's mothers, Anderson, but testimony came out that because the appellant did not have a driver's license, Anderson drove, even though the appellant is the one who asked for the use of the vehicle. So that shows that he is able to conform his conduct to the requirements of the law, only if, for no other reason than to not get caught so he can get the bigger score. He can conform his conduct to the requirements of the law when he wants to. And the evidence shows that. But there are some fundamental flaws with Dr. Bloomfield's testimony. It's somewhat backwards. He uses a diagnosis of low intellectual functioning to opine about the appellant's behavior. But that's backwards. He doesn't use an observation of the appellant's behavior in order to make a diagnosis. Well, why is that important? The woman who shares 4 children with the appellant had a 40-year observation period of the appellant's behavior. And what did she say when she was asked about that? She was asked, is the appellant smart? She said, I suppose so. Is he easily led? No, he is not. Again, she had a 40-year observation period. What Dr. Bloomfield basically said was that anybody who has low intellectual functioning necessarily wants to feel included and will look to a criminal element to seek that approval.
But counsel, Dr. Bloomfield's testimony alone, assuming there had been nothing else to the contrary, would have required the trial court to have found this mitigating factor, you would agree? In other words, that alone would have been competent substantial evidence that, if not rebutted in any way, would have supported the mitigating factor, correct?
Well, I'll take a slight issue with that.
Well, am I correct or am I not correct? And tell me why I'm not.
Well, just because the state did
Am I correct or am I not correct? And if not, then tell me why I'm not.
If you could repeat the question, Justice Luck, I'm
Yes.
sorry.
If, without anything else, without anything to the contrary, if the only testimony at the sentencing hearing had been Dr. Bloomfield's testimony and he testified as he did, would that not be competent substantial evidence that was unrebutted from which the trial court would have to find that mitigator?
I will say no, because this was a resentencing following Hurst, in that there is still evidence from this court's decision on original direct appeal where it upheld.
I know, but you're fighting my hypothetical. Answer my hypothetical.
Yes.
Okay. So I think the better course would be for you to tell me what evidence contradicted that from which the trial court could have rejected that testimony.
Right.
That's what I'd like for you to focus on.
And that's what I tried to
So
do.
I don't want to hear about the flaws in Dr. Bloomfield's testimony. I'm sure they're there. What contrary testimony was there that would allow the trial court to find, despite that evidence, that the mitigator should not apply here?
Sure. The fact that although he secured the vehicle from Anderson's mother, he had Anderson drive because he didn't have a driver's license. That's conforming his conduct to the requirements of the law. He planned this whole episode out. He was the ringleader. Testimony is very clear about the fact that he was the ringleader. The mother of his 4 children said he's smart and he's not easily led by others. That's evidence that rebuts that testimony from Dr. Bloomfield. Now, there is a testimony from Dr. Gold, but he did limit his testimony as to the impacts of PTSD only. He basically said he was looking at PTSD impacts, not the entire psychological makeup of the appellant, which is what Dr. Bloomfield was doing. But all of the evidence of planning, the incident regarding the law enforcement officers who wanted to detain him, not arrest him, but detain him, he dropped an article, it appeared to one of the officers, fled, he was tackled by the officers, and then he says, I give up, I give up. At that point, one of the officers went back to look for the discarded article. The appellant saw his opportunity and ended up in a gunfight with two officers. He shot one officer in the foot, he shot the other officer in the hand. He, unbeknownst to the officers, the appellant was also shot. He had a through and through. He runs back to his mom's house. He gets arrested. After the arrest, he's interrogated. He conceals from the authorities the fact that he had been shot, and he's looking at the chair to make sure that there's no evidence of blood. He's not the fool that Dr. Bloomfield portrays him to be just because he has low intellectual functioning. He did have a recent IQ test of 65, 66, but that's not dispositive in this case because when he was 8 years old, he had an 81 score. So again, that evidence is not expert testimony, but under this court's case law, that evidence does not square with the opinion testimony from Dr. Bloomfield. Therefore, the trial court could reject it. Now, that being said, even if it was an error for the trial court not to find that statutory mitigator, as was alluded to earlier, that underlying circumstance was considered under the intellectual impairment mitigator. And just as aggravators should be merged, this court has said that mitigators should be aggregated. That's footnote 3 in Campbell. Campbell's often cited for footnote 4, which has a list of that catch-all non-statutory mitigator regarding the life of the defendant. So again, the underlying circumstance was considered. The trial court found intellectual impairment and afforded that mitigating circumstance moderate weight. And if you look, it's the same testimony used to support one mitigator that's used to support the other. So there really is no error here, even if the evidence from Dr. Bloomfield was not rebutted. On to issue 3. That issue is controlled by this court's recent decision in Rogers. But what the appellant is basically doing is raising a process challenge to those 25. The appellant in issue 3 isn't really challenging the decision as to those 25, just the process that the trial court used to get there. But as this court essentially said in Rogers, under the abuse of discretion standard, the trial court doesn't need to be that detailed in its sentencing order. It has to consider the mitigators and it has to show and indicate that it did, but does not require the level of detail that Oyola suggested, which is why this court receded from Oyola in Rogers. And that brings us to issue 4, which is the 5 mitigating circumstances that the trial court said weren't mitigating. There is some confusion in the record as to whether or not the trial court said, yes, these are mitigating in nature, but there's no weight appropriate in this case, or if the trial court said they're not mitigating in nature. In the end, it doesn't matter because there's no reversible error. It doesn't matter if it's the abuse of discretion standard that applies or if it's de novo, because the evidence was not persuasive or it was considered under the catch-all intellectual impairment, there's no harm and there's no abuse of discretion if it had been afforded slight weight. And I'll read to you what the court said. The court said, although the jury unanimously found the greater weight of the evidence did not establish this mitigating circumstance, again acknowledging the fact that for every single mitigator the jury said no, the court went on to write, this court finds the evidence does not establish this circumstance. As the jury determined, however, this court now determines this circumstance is not mitigating. So to the extent there's any question about whether the trial court said it's not mitigating in nature or it's not mitigating in this case, it doesn't matter because the evidence was either subsumed by the intellectual impairment mitigator or it was just not very persuasive. So if it's de novo, then it's harmless error. If it's abuse of discretion, there was no abuse to afford it no weight.
How can you say they were subsumed when the 5 that we're talking about are, he struggles with depression, which was not any of the 3 that were there, that he's ineligible for parole, which I don't see how the 3 that were found could possibly subsume that he was placed in special education as a child, which, as you've stated, is very different from the low IQ that was found as an adult, that he was in a loving relationship with his family, which would actually seem to be counterindicative of some of the 3 that were found, and he has poor impulse control. That one may be close to subsumed, but it's hard for me to say that they're harmless because they're subsumed when they seem very different than the 3 that were found.
Well, I said, Justice Luck, they were either subsumed by the intellectual impairment.
Right, that's what I'm asking a question about.
Or they were just,
I'm not asking a question about the or. You said they were subsumed. How could they possibly be subsumed?
well, if you look at the testimony from Dr. Bloomfield, he says that the intellectual impairment directly, the intellectual impairment related to the impulse control problems that the appellant had.
The impulse control one, I agree, possibly could be, but I don't see how the other 4 could be.
I'm not arguing that they are. I'm
Okay, so
arguing-
given that they're not, how can we say that they're harmless if the trial court erred in finding that they were not mitigating in this case?
Because of the nature of the aggravation in this case. We have 4 prior violent felony convictions, all of them involving gun violence. 3 of them involving shooting victims. One of those victims was shot 6 times by the appellant. He testified at this resentencing that he still has 2 bullets in his body from that incident.
How can we say, though, that without knowing what the weight should have been for each of these, how that we would weigh it the same way? In other words, let's say the trial court erred and should have given each one of these great weight. How could we have weighed those 4 or 5 with great weight against the great weight that was given to the others and have reached that same conclusion?
Well, if you look at this case, there's no way that these would be entitled to great weight. Depression, for example.
How do we know that? If the trial court erred, how do we know that?
Because you can look to the record, and the testimony says that the defendant was depressed in the past because his father died. There's no nexus to the depression from the appellant's dad's death previously in time to this particular crime. There's just no nexus there, Justice Luck. So it's not persuasive.
Ineligibility for parole is a pretty big one.
Yes, but again, just because someone has a life sentence without the possibility of parole does not mean that society is forever protected from that individual.
Agreed, but again, we're talking about, you're asking us to essentially reweigh something where the trial court, again, assuming error, that the trial court erred here, and without knowing what weight the trial court would have given it, and us on a cold record trying to find out what weight we would have given it. That's a hard task for us to do on a harmless error review, it would seem.
I would disagree about your definition of harmless error. Harmless error analysis would not require this court to do a reweighing. Harmless error analysis is there a reasonable probability
That would affect the
change
result.
outcome?
I understand.
Correct. So there's
Without knowing the weight, though, how could I make that determination, I guess is what I'm asking.
because it's not persuasive and it wouldn't be given that much weight anyway. Because of the severity of the aggravating circumstance here. Again, 4 prior violent felony convictions, all involving gun violence with 3 gunshot victims. They're not contemporaneous. It wasn't like 2 were before, 2 were after. This is not a situation where the appellant, he voluntarily surrendered to police. He tried to trick the police, say, I give up, and then he engages in a gunfight. It's not a robbery gone bad. It may have been a robbery gone bad for his co-defendants, but this is not the first time that the appellant used gun violence to get what he wanted. Right? He's been down that road
Have we
before.
ever addressed whether ineligibility for parole is properly considered and weighed as a mitigator, to your knowledge?
This court has suggested that it is a mitigator, but the state takes some issue with that because there seems to be a presumption there that because the defendant is
You're
now
deciding whether the defendant should get the death penalty or life without parole. It seems odd that you would separately consider ineligibility for parole a mitigator when that's
Right.
the overarching.
there seems to be some presumption that underlies that somehow society is safe just because the defendant is going to spend his lifetime in prison. But there are many prisoners are still part of our society. Correctional officers are still part of our society. And there are numerous cases where inmates are killing other inmates. Right? And those inmates have families. They have loved ones. That's someone's brother, father, sister, mother. They're part of our society too. So this presumption that just because the person spends the rest of his life in prison means that we're safe is a false presumption. And then I understand that the state filed a notice of supplemental authority somewhat late in this case, particularly regarding the proportionality review. The appellant raised proportionality review as an issue in this case, and the state first argues that for all the reasons articulated by Chief Justice Kennedy in the dissent in Jacob, that proportionality review is unconstitutional given the conformity clause in the state constitution. In that dissent, there's a quote from the ballot description which talks about the minimum level of protections. So what the conformity clause basically says is we are bound in Florida to provide the bare minimum in the bare minimum only. We cannot afford additional safeguards because the people of the state have said no to that. Now, as to the majority decision in Jacob, it is time to revisit Jacob, particularly because of footnote 2. In footnote 2 in Jacob, it's basically a house of cards argument that if you take out the proportionality review card, the entire house of cards falls, and just because the U.S. Supreme Court has said this state's capital sentencing scheme is constitutional, doesn't mean that Florida's will be if you take out proportionality review. But the capital sentencing scheme at issue in 2014, when Jacob was decided, is not the capital sentencing scheme we have today. Today, in the post-Hurst world, the system that we have is indistinguishable from the California system that was upheld by the U.S. Supreme Court in Pulley. So now, if there was any debate about whether or not proportionality review was part of the bare minimum or was an additional safeguard, it is clear, unequivocally, that it is now an additional safeguard. Because it is an additional safeguard and not the bare minimum, this court cannot do it, because the people of Florida have said so through the passage of the conformity clause.
Did you argue this in your briefs?
No, and I apologize for that, Justice Polston, but, and I appreciate that opposing counsel did not have a large degree of time to respond to that argument. I would note that after I filed the notice of supplemental authority, I did contact opposing counsel by phone and told him the exact argument that I intended to make. And I know that's not an ideal situation. I was just trying to make the most of the situation and give the opposing counsel as much opportunity as possible. But I understand your concern, Justice Polston. And then lastly, in closing, with regard to issue 6, the appellant is seeking an extension of the categorical bar from intellectual disability to intellectual impairment, relying upon the evolving standards of decency. The conformity clause precludes that as well, but I will just close with one note that, as numerous dissenting opinions have said, the evolving standards of decency test is an unconstitutional usurpation of legislative power by the judiciary. Not by this judiciary, but by the U.S. Supreme Court. On that, the state asks that this court affirm the sentence under below.
If I could, I'd like to try to make three brief points on harm and then three brief points on the impaired capacity mitigating circumstances.
I'm going to give you 2 additional minutes, but
Okay, thank you, Chief Justice Kennedy. Yes, sir. On harm, Justice Luck, I think your questionings of the state in terms of how this court can find this harmless or conduct a harmless error review without reweighing, that goes to the fact that these types of errors hinder this court from conducting meaningful appellate review. Again, that's the critical reason for the trial court to thoughtfully and comprehensively analyze these circumstances and assign a weight and explain why it's not mitigating. The other point I would make is this court has stated in Knowles versus State that where harmless error is concerned, the question is whether there's a reasonable possibility that the error affected the verdict, not whether it substantially influenced the verdict. Here, there's a reasonable possibility that these errors contributed to the death sentence. I would also point out that even if the court considered Mr. Newberry's intellectual impairment and assigned moderate weight at a mitigating circumstances, that fact does not. Even so, even taking that to be the case, I would still argue that if the court had properly considered the impaired capacity circumstances to be proven, it would have needed to have assigned that more than moderate weight. Here's why I say that. Again, that would have directly related to his culpability. In addition, Dr. Bloomfield testified that it affected Mr. Newberry's capacity, his functioning at all times. And I would point out that in this case, not only did the evidence not only indicate that, fail to indicate that Mr. Newberry concealed his actions, it actually showed the reverse. He engaged in this crime with 3 men who he knew from the neighborhood. People saw the weapons out in plain view. He went to a nearby nightclub where his then girlfriend worked. If the trial court would have properly considered the impaired capacity circumstance, I think that would have been meaningful here. I would also point out that to the extent the court found that Mr. Newberry, and this is on the merits of the impaired capacity, to the extent it found that Mr. Newberry understood right from wrong, this court has made clear that just because a person is sane or knows the consequences, including right from wrong, that doesn't necessarily mean that his capacity is not substantially impaired. I'd also note that Mr. Andrews' driving, that's simply not competent substantial evidence. And I would just end by saying this.
Well,
Yes, sir.
why isn't it? I mean, because if someone decides he's not going to drive a car because he lacks a driver's license, that shows kind of a keen awareness of the requirements of the law and a carefulness to abide by certain requirements of the law.
Yes, sir.
So why wouldn't that be confident evidence?
Well, Chief Justice Kennedy, in that circumstance, it could be. But that's not what happened here. From the record, I'm not aware of there being evidence that there was some discussion, and Mr. Newberry said, I'm not driving, I don't have a license. In fact, the evidence that he didn't have a license came far later in the proceedings, as I recall. My understanding is that co-defendant Phillips drove. But I'm not aware of there being any.
So you're saying there's no evidence to show that there's any link between
Yes, sir.
between his decision not to drive and his lacking a driver's license?
Yes, sir. To my understanding. And if I could just conclude by saying, again, these errors hinder this court's ability to meaningfully review this sentencing order. And as a result, I would ask this court to reverse for reevaluation of mitigating circumstances in the sentence. Thank you.
All right, we thank you both for your arguments, and the court will now be recessed.
All rise.